after Nautage that you can have a partner, you can have cohabitation, you can live together, you can, my lord, enjoy your life together, but the ultimate fruition of marriage, which according to me is an essential right to enjoy the right to life fully for those who choose to marry, we will not recognize that and affiliate that, my lord, will not pass muster under inclusion. Then your lordship will find, even if there is no legislation, it will come under those narrow area of matters where a positive obligation will be found. That is not, my lord, a mandamus to mere mandamus to legislation.
Postulate is that these duties, affirmative duties of the state extend in the welfare area. But I said that, this is not just confined to the welfare area, but it can include the more political or the more social.
My lord.
They are obvious. This is, of course, in the realm of context of. But if you take the context of free speech,
Yes.
what is free speech if the situations are not conducive? If you are standing there and surrounded by 100 people who are armed, and the police is standing by, unwilling to help you,
Yes.
that freedom of speech is already illusory. There is no freedom of speech.
No freedom of
To that extent, the state is always under a duty to
Yes.
foster and facilitate the due exercise of fundamental rights. But this goes 2 steps beyond. First is you locate this as a right and then say you are under a duty.
Yes.
Even if we admit that there is a duty, what is that kind of duty? How do you crystallize that duty?
Yes, my lord. Then, now that's the next question, my lord. Now, kindly see, my lord, I want to place my case, dehorse this Special Marriage Act law. It has been argued without prejudice to them, my lord. I would not want to go from the statutory route at all. I somehow find, my lord, that this is a constitutional principle flowing from 21, and in deciding whether, my lord, an unenumerated right can be, my lord, inferred.
Vishwanathan, whatever, ultimately it will boil down to this. There is one constitutional doctrine which we have remained steadfast and constant to, that we cannot direct a legislation. We cannot direct the framing of a policy. We cannot enter into the realm of policy making or legislation. Now, short of that, what is the duty that you locate
Yes.
for them?
Now, my lord, the respectful answer to that is, even that principle, my lord, has various hues. Now, if there is a discrimination based on a core trait, as my lord, the Chief Justice called it in one judgment, even under inclusion, my lord, is no answer. We have developed it, my lord, in the note. A state may say, as it was said, my lord, in the special courts by, my lord, the senior Chief Justice, following West Coast versus Parish, that we will strike where the evil is most felt, or address the most imminent issue first. But in that, if suppose there are 10, my lord, prongs which are available and 7 are covered.
Degrees of evil.
In the 7,
Yeah,
what is the, my lord, legal answer in a claim for discrimination if in that 7 there is discrimination? Your lordships have, my lord, pondered over it and said, if the discrimination is based on a core trait of an individual, we will not recognize that under inclusion. Keep the relief part aside, my lord. Both in, my lord, the case with, my lord, the Chief Justice said, that is, my lord, this National South Indian River Interlinking case, or in the preemption case of Atam Prakash, where it was found that the included categories were keeping off consciously women. My lord, thus relatives of the same degree are excluded either because they are women or because they are related through women.
Constitutional prohibition. That would be relatively easier to answer.
Yes.
Because of 15(2). You have a proscribed category, directly proscribed.
No, my lord, here they were excluded.
Yes.
An inclusion
So
of women would have been justified.
No, you are excluding women.
Excluding women.
Excluding only.
No, my lord, I am only saying this under inclusion argument is not a final argument. It can go home in certain circumstances, but there are exceptions to it. My lord, look at National South Indian interlinking. While non-classification arbitrariness is tested based on the proportionality test, where the means are required to be proportional to the object, classification arbitrariness is tested on the rational nexus test. There is sufficient if the means share a nexus with the object. The degree of proof under the test would impact the judgment of this court on whether the law is under-inclusive or over-inclusive. A statute is under-inclusive if it fails to regulate all actors who are part of the problem. It is over-inclusive if it regulates actors who are not a part of the problem that the statute seeks to address. The determination of under-inclusiveness and over-inclusiveness and degree of deference to it is dependent on the relationship prong. Next para is very important, Milo. The nexus test, unlike the proportionality test, is not tailored to narrow down the means or to find the best means to achieve the object. It is sufficient if the means have a rational nexus to the object. Therefore, the courts show a greater degree of deference to cases where the rational nexus test is applied. A greater degree of deference is shown to classification because the legislature can classify based on the degrees of harm to further the principle of substantive equality, and such classification does not require mathematical precision. Indian courts do not apply the proportionality standard to classificatory provisions, though the two-judge bench in Anuj articulated the proportionality standard for protective discrimination on the ground of 15, held that less deference must be allowed when the classification is based on the innate and core trait of an individual. My lord, this is an innate trait of, my lord, non-heterosexual. An LGBTQ plus is a innate and core trait born with nature to them. How can it be said, my lord, that after noughtage, that you can have a partner, you can have cohabitation, you can live together, you can, my lord, enjoy your life together, but the ultimate fruition of marriage, which according to me is an essential right to enjoy the right to life fully for those who choose to marry, we will not recognize that and affiliate that, my lord, will not pass muster under inclusion. Then your lordship will find, even if there is no legislation, it will come under those narrow area of matters where a positive obligation will be found. That is not, my lord, a mandamus to mere mandamus to legislate.
Mr. Vishwanathan, even if the under inclusion is not valid in that
Yes.
sense, it's not a valid constitutional classification, because as you say, it is based on a core or innate characteristic.
Right.
Then there are two options to the court. You strike down the under inclusion as it is, or alternately, if there is an interpretative space available,
Yes, my lord.
you will mold the.
My lord, that has also been developed, my
But
lord.
then we are back to this. Do we really have an interpretative space left in the SMA?
Yes.
If we have, of course, then you are right.
No, my lord, there
But
is
if
a
we
solution.
don't,
My lord, there is a solution for that, and I must thank two
then
young.
merely striking down an under-inclusive classification doesn't serve your purpose also.
No, my lord. I will, my lord, address that, my lord, independent of the reading in part. My lord, two young writers, my lord, who have written an article on transgender inheritance, reached out to me by email and furnished to me a very well-researched article produced by them, published in Karan Gulati and Tushar Anand. I have placed that for your lordship in the Indian Advocates Review. They say, my lord, after Nalsa, your lordship's judgment led to the Transgender, my lord, Protection from Discrimination Act. But inheritance issues are not addressed there. Workability issues still may remain. But that will not deter Parliament from enacting that legislation and recognizing that right. Non-binary, my lord, people, the inheritance is a serious issue which is being addressed on a case-by-case basis. So, workability will not hold back your lordships from declaring that there is a right in them to marry, because that is an essential right to effectuate their right to life. My lord, I will come back to my lord's query on the right. If so, my lord, that declaration will be worked out by Parliament. To that extent, my lord, there is a positive obligation. Property rights, my lord, other neighboring countries have amended their statutes, worked out proportion for transgenders based on male, female, non-binary. Non-binary, they give the average of the two, my lord. Look at how, and my lord, I am talking of Pakistan. I got the statute. Nepal has amended. These young authors have referred to it in their article, my lord.
Nepal recently, Sri Lanka, the bill
Sri
was
Lanka.
upheld.
Sri Lanka,
The
my lord,
bill
they
is
have
not
Bill was upheld.
upheld, my lord, upheld day before yesterday, upheld with, my lord.
And they've
So,
cited Navtej
yeah,
itself.
now, Tej. No, my lord, when I transpose myself
bill has
to,
been upheld.
It is the bill which is upheld.
yeah.
Bill which is
You know, they have a procedure. It happened in
Yes,
the
it
in the
goes-
devolution case also.
like an advisory jurisdiction.
Advisory jurisdiction, my lord.
Even South Africa has that.
South Africa also has, my lord, this suspending it and leaving it to Parliament.
It is not a practice.
Yes. England has, my lord,
Mr.
declaring
Vishwanathan,
it.
It is not a practice.
Yes. It is, my lord, mentioned in the
It
article
is
1.
not a
Some of the
practice.
civil
It
law
is a
countries.
matter of constitution.
Constitution. It's a matter of constitution. No, my lord, I only sometimes, my lord, abstract questions lead to answers. Suppose in 1950, with Article 245, 246, List 1, 2, and 3, no laws are enacted. There is absolute, my lord, silence, with only pre-constitutional laws being saved under 372. Would your lordships have stepped in or not? In a narrow area to protect certain basic, my lord, rights. Suppose nobody enacts a law. You can't apply Asif Hamid, the service matter, and say that we don't, under
Vishwanathan,
309.
We were not lacking in laws. There were too many of them.
Well,
They had to be
so, my lord,
aligned.
so
That's why
otherwise, my lord, we would not have had
In the
PUDR.
Laws Act was precisely that.
A reference to
aligned
made to your
law.
lordship. My lord, we would not have had, my lord, Vishaka. Vishaka, as your lordship rightly said, was taken in the right spirit, and the Posh Act was enacted, my lord, thereafter.
All right, Mr. Vishwanathan,
Milord,
should we conclude now with
My
your
lord,
submission?
I will leave my space to others. My lord, will of the people is actually the constitution.
Yeah, it's there.
Both B.R. Kapoor, Supreme Court advocates on record, and the NJSC judgment. My lord, workability, I have given your lordship the transgender example. Non-inclusion, under inclusion, I give your lordships the inner court trait test, my lord. And the only other aspect that remains is, my lord, the argument of the learned additional solicitor, Ms. Aishwarya Bhati, my lord, on the material produced, my lord,
Your item.
Ms.
7.
Tara assisting me as the last segment prepared it, and para 63, I will only read and conclude. The reliance placed by, my lord, National Commission for Protection of Child Rights on articles claiming risks and harms of gender-affirming healthcare is in complete derogation of, my lord, the WPATH guidelines. That is, my lord, World Profession Association for Transgender Health, which are well recognized and followed in India. Reliance on such article furthers the stigma against transgender person and supports the unscientific claims to deny transgender adolescents gender-affirming healthcare, which is a statutory obligation of the state under the Transgender Persons Act. So, my lord, my respectful submission is your lordship will see this note at leisure. There is, my lord, a right. It is required to effectuate the final right, and that, according to me, will be the test for unenumerated rights. If something is ultimately, my lord, the doctrine of implied power test in normal statutes. If a right is required to effectuate my right to life fully, and if by choice I want to marry and bring my association to fruition, and if there are ethical considerations in a marriage also, my lord, between non-heterosexual, they should also have commitment to one partner. They should also have rights in divorce, my lord. It's not only association. Pauri addresses, my lord, the problem of separation in a homosexual marriage. It has to be dealt with. You can't leave one partner destitute. My lord, High Court of Australia, Justice Michael Kirby, when he was to retire, the Attorney General moved an amendment in the pension bill, my lord. We have got material on that to bring so that his partner is, my lord, covered at that point. That was the, my lord, approach they took in the early 2000s. My lord, so the submission is, my lord, that all encompassing, my lord, right, and my lord, ethical underpinnings also, they should be my lord, put to the rigors of the ethics of marriage also, my lord. It's not that, my lord, these people, as it was called, could be left to, my lord, stray away from commitments, my lord, in a marriage. So your lordship, my lord, will declare their right to marry, and, my lord, find a positive obligation in them to enact, so that, my lord, they are not deprived of basic rights, my lord, which flow from a marriage, apart from the acceptance, my lord. And my lord, Kohli says, your lordship says that fundamental rights by very nature are a limitation on the legislative power of the state. You can't leave it to, my lord, the majority, my lord, to decide what they feel, because it's ultimately your lordships are the sentinel on the cow. I'm very grateful for this.
Thank you, Mr. Vishwanathan.